After almost 2 decades, the fight for a broadband internet to be treated as essential service like water or electricity has come to an end. In a landmark decision, the U.S. Appeals Court for the Sixth Circuit struck down the Federal Communications Commission's net neutrality rules. The ruling stated the FCC did not have the authority to stop telecommunications companies from blocking or slowing access to internet content. And for more, I want to bring in Brent Skorup, legal fellow at the Cato Institute. Brent, great to be with you today. Net neutrality is basically about equal internet access. So explain to us what happens when the net neutrality rules are lifted.
Sure, I expect your average internet user will not see much of a difference. The net neutrality rules, what it really is giving the federal government broad authority to regulate the internet, and this is something that Congress did not want the FCC, the Federal Communications Commission, did not want the Federal Communications Commission to have this broad authority over the internet. And the FCC has fought for several years to regulate internet companies, like you said, like common carriers, like the old AT&T monopoly and airlines and so on. But as the Sixth Circuit said, the FCC doesn't have that authority.
Yeah, and as you said earlier, not a lot of changes for consumers, but anything else for us to think of when it comes to this?
This has been a long-term debate about what powers the government should have over media distribution. Some viewers might remember the fights about the fairness doctrine and regulating broadcast radio and TV in the past. And so I was gratified to see the Sixth Circuit strike down the FCC's attempt to bring these legacy regulations to the internet. I think it distracted a lot of people, and particularly our regulators. They could have been doing things that would benefit the average person, like expanding broadband into rural areas, improving the subsidy programs, but they've been caught in this net neutrality debate for a long time, and I think it's harmed the agency and its priorities as well as consumers.
Brent, in their opinion, the 3-judge panel cited a Supreme Court decision in June known as Loper Bright. Can you tell us a little bit more about that case and how that connects to net neutrality?
So Loper Bright was a transformative decision by the Supreme Court in that it overruled a previous Supreme Court decision, which the Supreme Court doesn't do often, a case called Chevron. And the case called Chevron in the 80s, the Supreme Court said, we're going to defer to agencies when they interpret a statute from Congress. We're going to give an agency a lot of deference when they're interpreting a statute. After, in this case, this net neutrality issue came up because this is ping-ponged for over 20 years between administrations, where the FCC imposes strict regulations on internet companies, and then a Republican administration comes in and repeals those strict regulations, and it's gone like that for a while. Supreme Court, in a related case, said this gives companies no predictability. You can have this whiplash effect as administrations change, and so we're not going to give this deference to agencies. Congress needs to write statutes more clearly if they want agencies to enforce them. We're not just going to give agencies a lot of these self-interested agencies a lot of power. And so the court yesterday in the net neutrality case, as you said, cited this Loper Bright decision where the Supreme Court said no longer will agencies get deference. Courts will have to interpret the statutes in the first instance, not the agency.
All right. Well, Brent, thank you so much for weighing in. We really appreciate it.
Thanks for having me.